single day.
In Charlotte County, Florida, Sheriff Bill Prummell police a for-profit is job one. Our hands are tied. In neighboring counties, public defenders take contrasting approaches and their clients see widely disparate results. By Daphne Durrett, Josh Salmon, and Michael Braga, Gatehouse Media. Diamond Liddy and Carrie Howout were elected to represent criminal defendants too poor to hire a private attorney in neighboring Martin and Palm Beach counties. The longtime public defenders have little else in common. Liddy's a marathon runner who is best friends with her region's state attorney and married to a recently retired judge. She believes the system works best when her assistants get along with their opponents. Howout smokes cigarettes as she paces the pavement outside the courthouse awaiting verdicts in cases she takes to trial. She maintains only a cordial relationship with her county's top prosecutor and pushes her assistants to fight for everything from bond relief to acquittals. Each believes her approach brings the best results for clients. But Liddy's clients spend twice as long behind bars for the same crimes, an investigation by the Palm Beach Post and Sarasota Herald Tribune found. Black defendants suffer the most. In fact, Martin County is the worst place in Florida to be a black person accused of a crime. See Influence, A14. HeraldTribune.com. Influence. Public defender Diamond Liddy, whose 19th Judicial Circuit includes Martin County, believes the criminal justice system works best when her assistants get along with the attorneys working opposite them. James Wooldridge / The Palm Beach Post. Continued from A1. Doing criminal defense in Martin County is like trying to pursue civil rights in Alabama in 1965, Robert Watson, a Martin County criminal defense attorney, said in a 2016 interview. Rights for defendants are just not welcomed. The newspapers spent 5 months analyzing 2 massive statewide databases and hand-compiling the details of more than 800 felony drug cases by 8 assistant public defenders in Martin and Palm Beach counties. Reporters reviewed university studies and interviewed more than 20 lawyers, legal experts, and criminal defendants. They found Howout and her assistant public defenders are more likely to file motions on behalf of defendants. They are better at getting bail and charges reduced and more successful at securing shorter sentences and lower fees. Bail rates, fines and fees are twice as high in Martin County, and nowhere in Florida do blacks spend as long in lockup for felony drug crimes. Black defendants busted for drug offenses in Martin average nearly 3 years in state prison. Whites in Palm Beach County average just 3 months in jail. Florida's criminal justice system is not supposed to work this way. The legislature established sentencing guidelines so defendants will be treated the same from Pensacola to Key West regardless of race, gender, or financial wherewithal. For the past 3 years, Gatehouse Media has been examining racial disparities in Florida's criminal justice system. The newspaper chain published Bias on the Bench in December 2016, an investigation of millions of court records that showed black defendants across the state average much longer sentences than whites who committed similar crimes. The series focused on the sentencing patterns of individual judges, blaming them in part for the disparities. Judges fought back, arguing that bias in the system had more to do with plea negotiations between prosecutors and defense attorneys, where 95% of criminal cases are resolved. Prosecutors control much of that process, deciding what charges to bring, what pleas to offer, and whether to go to trial. Defense attorneys are supposed to serve as a check against their power, championing the rights of the accused while keeping punishment as low as possible. In Martin, public defenders appear to be losing the battle. Liddy says political reality in her jurisdiction makes it difficult to take a scorched earth approach toward fighting for her clients. A Republican like her predecessors in the 4-county 19th Judicial Circuit, Liddy says the conservative jurors in Martin make prosecutors smile when one of her assistants dares to take a case to trial. She adds that her adversaries at the state attorney's office are much tougher than those working in Palm Beach County. The same goes for the judges. Liddy was one of the strongest voices in defense of judges after the Bias series first ran. She took exception to Gatehouse Media's profile of a Treasure Coast judge and said individual case comparisons overlooked nuances, such as whether a defendant cooperated with police. But when confronted with the comparisons between outcomes for her clients and holdouts, Liddy pointed back at the same judges she defended. "It's just what it is here. The judiciary is really tougher, and I'm not criticizing them," Liddy said. "We can say a judge issued a harsh sentence. However, if the line is not crossed as far as legality, our hands are tied." Liddy says the sentences reflect what people want in Martin County, and she makes no apologies for her relationship with State Attorney Bruce Colton. "He's one of my best friends," Liddy told the Post. "I'm not embarrassed about it." On Liddy's desk sits a photo of her with Colton's late wife, Rebecca, holding medals they won during a marathon. Rebecca Colton, who passed away 7 years ago, served as Liddy's campaign treasurer in 2008. But Liddy's fellow public defenders in Florida say her relationships with opponents in the criminal justice system are too close for comfort. "We have public defenders in Florida literally and figuratively in bed with judges," said Larry Ager, the public defender in Sarasota's 12th Circuit. "It undermines the integrity of the entire public defender system." Tied with the other side. The differences in Martin and Palm Beach County go as far back as the modern concept of the American public defender itself. It was a U.S. Supreme Court case from Florida, Gideon v. Wainwright, that required governments to provide attorneys to defendants who couldn't afford one. Florida lawmakers established the Office of the Public Defender in 1963. A decade later, Richard Jorandby held the seat in Palm Beach County and Elton Swartz in the Treasure Coast. As Jorandby gained national recognition for running one of the best public defender programs in the country, Swartz was trying to get the state attorney to relax his policy of not offering plea bargains ever. Liddy was a teenager back then. She grew up in Fort Pierce, the only child of Bet and Larry Liddy. Her father, a charter boat captain turned real estate agent, ran unsuccessfully for public office 5 times. She graduated from a private Catholic school in 1975. She got her bachelor's degree in political science at Rollins College in Winter Park, briefly taught algebra, and went on to work as a legal assistant for Broward County prosecutors while she earned her law degree at Nova Southeastern University. Liddy went straight to the prosecutor's office after law school, serving for 6 years under Colton. In 1987, she left her friend and mentor to help open the first all-female law firm in the Treasure Coast. She parlayed her work as a prosecutor to score a few high-profile clients, including Port St. Lucie's Police Union. In 1992, Liddy ran for public defender, coasting to victory on the same night voters across the nation elected Bill Clinton president. She prided herself on cutting costs, collecting fees from the criminal defendants she represents, and helping felons integrate back into society. She also championed a practice where fees go toward victim restitution before paying the court system. But as time went on, Liddy faced criticism for not doing enough to represent the people she was sworn to defend. In 2005, a jail crowding study commissioned for one of the 4 counties overseen by Liddy blasted her for letting poor clients languish behind bars for at least 30 days without legal representation. The report said that her staff made little effort to reduce bail rates, among the highest in the state, and that they were not aggressive about challenging probable cause for arrests. There seemed to be little of the philosophical antagonism towards the prosecution and courts often found in other public defenders' offices, the study said. Liddy's pro-prosecution, pro-law enforcement views also caused distrust among criminal defendants, the study said. The lack of a vigorous defense contributed to excessive criminal charges and longer sentences. It was obvious there were major problems in the system, and the most important was the public defender, said Alan Kalmanoff, a California-based consultant who wrote the study. She worked at the state attorney's office and was good friends with the state attorney. That's a bit unusual, a public defender being that tied with the other side. Liddy says it's absurd that anyone would think her friendship with Colton or her 25-year marriage to former St. Lucie County Judge Thomas Walsh would affect her defense of poor clients. See Influence, A15. Alan Kalmanoff authored a jail overcrowding study in 2005 that criticized Diamond Liddy for being pro-prosecution and pro-law enforcement. Amy Hareworth/cu-citizenaccess.org. Richard Joranby had served as public defender for the 15th Judicial Circuit for 28 years when Carrie Holloway, who had worked her way up the ranks in his office, defeated him in the 2000 election for the job. The Palm Beach Post/Richard Graulich. Larry Ager, the public defender in Sarasota's 12th Circuit, said it undermines the integrity of the criminal justice system when public defenders are cozy with their opponents. Herald Tribune staff photo/Mike Lang. Continued from May 14. It's laughable, Liddy said. To some extent, I can't care about their assumptions. I know my life. Both she and Colton say they never talk about cases when they're together. And even if they did, Colton said, there's no way his friend would roll over to appease him. Anyone who really knows Diamond knows that Diamond is an extremely competitive person, Colton said. We're not friends. Unlike the homegrown Liddy, Carrie Holloway, 61, was born in Pennsylvania, in the heart of Amish country, to an architect and a homemaker who divorced when she was 16. She moved with her mother to Stuart, graduated from Martin County High School and went on to New College in Sarasota. There, she found a passion for criminal defense after a stranger climbed through one of her windows and raped her at knife point. In a 1994 interview with The Post, Holloway said she remembered sitting in her tiny Sarasota apartment while nearly a dozen police officers plodded about. She worried they were destroying the crime scene. Her skepticism turned to anger weeks later when police tried to pressure her into picking someone out of a lineup even after she repeatedly stressed that none of them resembled her attacker. She was outraged that they wanted to pin her rape on someone she couldn't identify. After graduating from New College with degrees in sociology and economics, Holloway went to law school at Florida State University and finished at the top of her class. She settled in Palm Beach County, where she climbed the ranks as an assistant public defender, ultimately taking charge of the office in 2001 after defeating Joranby in the 2000 election. Throughout the 1990s, Holloway had earned a reputation as one of the region's best defense attorneys. But the campaign against her former boss divided the office, and high turnover marked her first year at the helm. Assistants loyal to Joranby scribbled quips like "Who's next?" and "Had enough?" on flyers posted around the office for going-away parties. Enraged, Holloway called an office-wide meeting and yelled at her new employees. She feared clients would see the flyers when they came to meet with their government-appointed lawyers. Their problems, she told them, are a whole lot worse than any of the problems I've seen in the office. If staff attorneys disagreed with her philosophy, it was time for them to move on. She promoted scrappy young assistants and took the lead in celebrating every acquittal in the office. Ever the trial lawyer, Holloway has long carried her own caseload. Even now, when she delivers an opening statement or closing argument, the courtroom is packed with her assistants and private defense attorneys alike. Holloway attributes much of her success to judges in Palm Beach County who are willing to listen. She adds that the preparedness of her attorneys to take cases to trial forces prosecutors to negotiate better plea deals. From my perspective, our willingness to litigate cases rather than take plea deals establishes pressure on the system, she said. And no one has ever accused Holloway of drawing too close to her fundamental adversary in the criminal justice system, State Attorney Dave Ehrenberg. We have a cordial interaction, but it's not a social interaction, Holloway said. We're not friends. Recipe for a sentencing disaster. Paul Petillo has spent 6 years studying thousands of criminal cases in Martin and Palm Beach counties. One of Holloway's chief lieutenants, he's also in charge of appealing decisions on behalf of the poorest clients in 3 judicial circuits, including Liddy's from Vero Beach to Fort Lauderdale. From the start, Petillo said he was shocked by how much longer defendants in Martin County spend in lockup for the same crimes. Last year, he studied sentencing trends in the 3 circuits and found Martin defendants who did not score a prison recommendation under state sentencing guidelines were 5 times more likely than their Palm Beach County counterparts to be sent to prison anyway. The most heartbreaking thing is when you see the pictures, Petillo says, of clients with lengthy prison sentences. Some of them, the only family photos they've ever had with their loved ones is from their visits in prison. The Post and Herald Tribune found the disparities in sentencing for felony drug crimes to be even more pronounced. The 2 newspapers collected more than 800 cases handled by 8 assistant public defenders, 4 from each county, from 2014 through 2016. The analysis revealed that drug offenders in Martin County were 9 times more likely to be sent to prison when they scored less than 44 points, the level at which prison is recommended on their sentencing score sheets. The newspapers also added felony drug defendants who scored 44 points or more to the analysis, creating an index that measures how sentencing in the 2 counties deviates from the minimums recommended under state law. That index shows that Martin defendants are far more likely to get extremely harsh sentences, at least 60% higher than the minimum, while Palm Beach County defendants are far more likely to be treated with leniency, receiving sentences at least 60% below the minimum. Of the 223 defendants in the index, 59 received extremely harsh sentences. 50 were from Martin County. On the flip side, 38 defendants received extremely lenient sentences. 32 were from Palm Beach County. Baby John Cherry is one of those Martin County defendants. The 22-year-old black man pleaded guilty to possession of a small amount of cocaine and obstruction of justice for trying to throw the drugs out the window while speeding along Interstate 95. Cherry had never been to prison before, had only 1 prior drug arrest for marijuana possession, and scored 34 points, 10 points below the level at which prison is recommended. But Cherry was sent away for 13 months. It was the same for Rufus Miley, a 45-year-old black man from Indiantown who got busted for cocaine possession. Miley scored 36.6 points but was sentenced to nearly 15 months in prison. Then there's Ben Smith, a 63-year-old black man who was pulled over for failing to stop at a stop sign and was found with packages of crack, pot, and meth in his pocket. His score of 69.1 points means a minimum of 2.5 years behind bars. But Martin Circuit Judge Stephen Levin gave him 15 years because that was the punishment he received the previous time he was busted for a drug crime. And it usually doesn't get much better each time you come to court, Levin said during the sentencing hearing. If the public defenders are not always fighting for the defendant and just rolling over, they could create widespread disparities throughout a circuit, said Derek Bird, a prominent Sarasota defense attorney. If you have a pushover public defender, a judge that's pro-state, and an aggressive prosecutor, that would be a recipe for a sentencing disaster. I didn't want to go back to prison. Just after midnight on June 19, 2015, a Delray Beach police officer on patrol saw a gold Toyota Camry blow past a stop sign. Nearly 9 months later and 55 miles north, a pair of Martin County Sheriff's deputies saw a black sedan run a stop sign, too. In both cases, the traffic stops ended with an arrest. Both men were in their mid-40s. Both had extensive criminal records. Both were caught with crack cocaine. According to the Delray Beach officer who arrested Alfred Johnny Hunt, the 45-year-old black man threw a wad of cash and a few crack rocks out his passenger side window as soon as he saw the police officer's lights behind him. See Influence, A16. As state attorney for the 15th Judicial Circuit, Dave Ehrenberg oversees prosecution of the defendants Kerry Howout's office represents. Bruce R. Bennett / The Palm Beach Post. Assistant Public Defender Paul Petillo was shocked by how much longer Martin County defendants spend in lockup. The Palm Beach Post / James Wooldridge. Alfred Hunt. Michael Green. Continued from May 15. In Martin County, deputies said Michael Green, a front seat passenger in the black sedan, told a deputy that he had a glass pipe in his pocket. Moments later, he tried to make a run for it but didn't get very far. One of the deputies escorted him to the ground, the police report said, and a subsequent search turned up 2 glass pipes and about $50 worth of crack. Because the men had similar criminal records, both received similar scores under Florida's guidelines. Green, with a previous aggravated battery conviction, scored 44.3. Hunt, once convicted of attempted second-degree murder, scored 47.6. Assistant public defenders in both cases negotiated plea deals with prosecutors. Hunt got 6 months in a jailhouse drug treatment program. He has since been able to rebuild his life, earning his commercial truck driver's license and landing a job driving a big rig. He said the first deal prosecutors offered him would have returned him to prison, but he credited Palm Beach County Assistant Public Defender Courtney Wilson with negotiating a better sentence. "I told her to talk to the state, and I told her that I didn't want to go back to prison," Hunt said. "She did, and I ended up getting the 6 months. Green, by contrast, was sentenced by a Martin County judge to 2 years in prison. Although his release date is set for October, Green said in a letter to the Post that he hopes to get out as early as August with good behavior. "I truly think I shouldn't be here," Green said. Colton thinks Green got a good deal. He said Green had violent felonies in his past and the sentence was less than half of the 5-year max allowed under the law. He thinks it's a bigger outrage that Hunt got 6 months. "To me, that's ridiculous," Colton said. "You're supposed to lose." Criminal defense attorney Doreen Regent joined Liddy's office in 2004 with the idea that she could make a difference. After assistant attorneys lost a big case, Regent said, Liddy would console them. She would smile. She would say they did a good job. She would encourage them to get over it. I would hear her tell them, "You're supposed to lose, that's how the system works," said Regent, now in private practice. Conversely, when Regent's ascent to the felony division brought with it a streak of wins at trial, no one said anything. Not a call. Not an email. Not a single word. It was weird, she said. After what would be her last string of 2 consecutive wins in the office, Regent was called into a meeting with Liddy's top assistant. She thought he wanted to talk about the recent victories. "Instead, he told me I was coming up on 6 years there," Regent said. "And it was time for me to move on." He helped her pack up her desk and escorted her to her car. During a meeting with the Post in October, Liddy shook her head at Regent's assessment and attributed her forced resignation to poor work performance. She said the claims are totally false and inaccurate, explaining that she congratulates assistants at monthly meetings for everything from acquittals to motions won. She adds that any attempts to paint her lawyers as not aggressive are unfair. One hand tied behind their backs. If her office were the problem, Liddy says, private defense attorneys would fare better in the local system. The Post and Herald Tribune did not analyze individual cases of private defense attorneys, but state court data shows the private defense bar in Martin actually performs worse than public defenders both in terms of sentence lengths and disparities between black and white defendants. Private defense attorneys who practice in both areas still blame Liddy. That's because her office handles at least 2/3 of defense cases in the 4-county circuit and they believe how she handles them sets the tone for the remainder. She has dedicated, talented people working for her, said Donnie Morrell, a criminal defense attorney based in West Palm Beach who practices in Martin. But she sends them into battle with one hand tied behind their backs. They are ordered not to go to trial or even demand jury trial. Morrell believes that emboldens prosecutors to take the same hard line with private defense attorneys. If prosecutors know that you're not going to go to trial, what incentive do they have to offer you a plea? Morrell asked. Palm Beach County public defenders filed nearly twice as many motions as their counterparts in Martin in the cases reviewed by the newspapers. That includes many more motions to suppress evidence and motions in limine, which challenge what jurors get to hear at trial. The data also show that public defenders in Palm Beach County were 8 times more successful at getting charges reduced. That's a big indicator of the level of fight that's being exerted by a public defender's office, said Blaise Trettes, the public defender for Florida's 18th Circuit including Brevard County. Among the beneficiaries of hard-charging assistant public defenders in Palm Beach County are Matthew Gaines, Nathaniel Green, and Gary Coney. All three black men were convicted of drug possession or possession with intent to sell and faced more than a year in prison. But they ended up with sentences of no more than a month in jail. John Hetherington, an assistant public defender for more than 3 decades and supervisor of the Martin County office, said he's not surprised the sentences are harsher in his county. Like Liddy, he believes tougher judges and more conservative juries contribute to the wide differences in sentence length. But he thinks the biggest problem is with Florida's criminal punishment code. He said he's seen sentences trend higher and higher since the changes in the late 1990s, and he and his colleagues have been powerless to stop it. And now here we are, he said. This is the reality. Continually outraged. HOWOUT does not feel powerless when it comes to defending her clients. We can do something, she said. We can fight. And fight she does. This summer, the Palm Beach County State Attorney's Office tried to make plea offers conditional on the requirement that defendants pay double the prosecution costs set by state law. That would have brought fines and fees in Palm Beach in line with what the court system in Martin charges. HOWOUT was indignant. She said prosecutors were trying to fatten their coffers off the backs of poor people by making the deals contingent on the higher fees. Her assistants filed challenges in the nearly a dozen such cases, asking judges to force prosecutors to prove the extra fees were warranted. Prosecutors eventually backed off in those instances. When they challenge her office again, HOWOUT says, she and her assistants will be ready. I'm just sort of continually outraged by it, HOWOUT said in an October phone interview. HOWOUT has been equally pugnacious when it comes to drug court, a pretrial diversion program that allows charges to be dropped if first-time drug offenders are able to go through a rigorous but therapeutic program that includes random drug testing, counseling, and regular court appearances. In Palm Beach County, a defendant's case remains open while in drug court, which means the defendant can still go to trial or work out a plea deal if the program proves to be too difficult. In Martin County, drug court candidates have to make an initial plea of no contest to get into the program. That means they are permanently relinquishing their right to fight the charges against them. If their attempt at getting through drug court later fails, their only option is to see Influence, A17. Alfred Hunt, who served 6 months in a jail treatment program for crack cocaine possession, has since been able to rebuild his life as a truck driver. Deed Smith / for the Palm Beach Post. West Palm Beach defense attorney Donnie Morrell, who also practices in Martin County, says he believes the public defender's offices set a precedent for the types of deals private attorneys can negotiate for their clients. The Palm Beach Post / James Wooldridge. Continued from May 16. Beg for mercy from a judge, who can impose up to the maximum 5-year sentence on a third-degree felony. HOWOUT says prosecutors in Palm Beach County have tried to change its drug court program to be more similar to Martin's, but she has fought it at every turn. She says many of her drug offender clients may still be battling addictions or going through withdrawals when they make their decision early in the case and aren't in the best frame of mind. There's no real time to review the case to even see if it is something they should plead to, HOWOUT said. It's like they create crime. From policing to prosecution to judicial discretion, the system is stacked against blacks in Martin County. A far greater percentage are arrested and convicted than whites. Blacks face much higher bail and are sentenced to much more time behind bars. Data compiled by the Post and Herald Tribune show that twice as many blacks are busted in sting operations in Martin, where undercover cops and confidential informants fish for low-level dealers. Blacks in Martin are also 3 times as likely to be arrested within 1,000 feet of churches, schools, parks, or other drug-free zones, a classification that boosts sentence length. Law enforcement officers in Martin County have even been known to lure dealers from across the Palm Beach County line, knowing the punishment will be more severe. Jack Fleischman is a West Palm Beach criminal defense attorney who handles cases in both counties. He said 2 of his Palm Beach County clients told him the first time they ever set foot in Martin County was when a confidential informant convinced them to meet in a parking lot near a Cracker Barrel. That location also happens to be across the street from a county park, making it a drug-free zone. I really think they've run out of drug dealers, so they try to bring them in from out of town, Fleischman said. To me, it's like they create crime. And everyone knows in Martin County you're going to get hammered. Martin County Sheriff William Snyder did not argue the point. He said his deputies absolutely do lure drug dealers in from Palm Beach County. If a drug dealer in Palm Beach County makes the strategic decision to come to Martin County to sell drugs, then maybe they ought to think about that, he said. Everybody has Google Maps. You know what county you're in. You can see how far away the parks are. But Snyder added that he's disheartened by any numbers that show blacks are treated more harshly by the criminal justice system. Those problems need to be addressed if they exist, he said, but it's not his office's fault if they do. The wide racial disparities in sentencing on either side of the county line have garnered attention from beyond South Florida. Last year, Florida State University's Project on Accountable Justice came out with a study showing Liddy's 4-county circuit has the worst racial disparities with respect to imprisonment rates in the state, while Howard's single-county circuit was the fairest. 1 in 24 black adults in the Martin circuit is in prison. In Palm Beach County, it's 1 in 84. We should provide an equal criminal justice system, and we should treat people doing the same things the same, and we don't, said Deborah Brodsky, director of FSU's Project on Accountable Justice. We don't have one criminal justice system. We have 67. You have very different policies, and it doesn't always serve the public's best interests in the end. These differences are expensive. While taxpayers across Florida spent $9.6 million housing the 483 people convicted in Palm Beach County in 2015, they shelled out $16.8 million for 839 prisoners from Liddy Circuit. I resent that as a taxpayer, because although I live in Leon County, I'm the one helping to pay to incarcerate the people that you are being so tough on, said Scott McCoy, Senior Florida Policy Counsel for the Southern Poverty Law Center. So if Martin County people want to pay more taxes for their tough-on-crime policies, then maybe that's something we should look into. But what they're doing now is a horrible idea. It doesn't make any sense. As surprised as Colton is about his circuit's dubious distinction in the study, the state attorney disagrees with Brodsky and others who advocate for a more homogeneous justice system. I think the people who get sentenced to prison are the people who've earned it, Colton said. He shoots back at people like McCoy who complain about the higher incarceration costs by asking if they would rather the system not incarcerate anyone at all and instead move prisoners into his neighborhood. Attorneys in Martin County don't expect things to change anytime soon. But if anyone could make things better for criminal defendants, they say it would be the public defender. Liddy could fight harder to reduce sentences and bring down bail rates and fines. But even then, some attorneys fear it could get worse for defendants before it got better. That's because fighting would entail taking more cases to trial, according to Jeff Smith, who has served as a Martin County criminal defense attorney for more than 2 decades. Though a few clients would win, most would lose and would get hit with longer sentences than they would have received by taking plea deals. If I tell my client it would be best for the system if you go to trial, but better for you if you take this plea offer, Smith said, then as a criminal defense attorney, I have to advise my clients to do what's best for them. Smith and other attorneys wish someone in Martin County would take a risk. If my client is young and black, and they see me chumming it up with prosecutors and judges at a restaurant, who do they think I'm serving, said Broward County Public Defender Howard Finkelstein. I'm only serving one master, and that's the client. For Finkelstein, the best part of being a public defender is the ability to look a judge in the eye and say, no. If you don't have that fire in your belly, he said, you shouldn't be the public defender. Carrie Howard, the elected public defender for the 15th Circuit in Palm Beach County, prides herself on being prepared to take cases to trial. Damon Higgins / The Palm Beach Post. Copyright 2018 Herald Tribune, all rights reserved. Restricted use only December 2, 2018.
Hey Charlotte County, this is Charlotte County COPWATCH. I am using any video here with under fair use if you have criticism, reporting, teaching, etc. And please donate. I do not make money from YouTube, and there are different ways to donate in the video links. Thanks.